Hi everyone, welcome to Adamya Academy YouTube classes. So till yesterday we have discussed about various schools and legal theories as well as legal rights and duties. So we have left one school which is the realistic school. So today we will be discussing about the realistic school of jurisprudence and what realistic school of jurisprudence has to tell about. So let's start. Realistic school of jurisprudence. Realistic school is a type of school which focuses on decisions. They believe that law is only an official action. So the key word here is judicial decisions. When we were discussing in short about this school, I have told you that realistic school does not see how the law has come into force or how the law should be. Rather, it sees that what is the law right now. So it focuses on the judicial decisions or the judgments given by the judges or the lawyers. Debates. They believe that law is only an official action. This school is also known as realistic because it focuses on approach that studies law as it is in the actual working and its effects ahead. This school rejects traditional definition of law and also avoids any dogmatic formulation and fully concentrates on decisions given by the court. So this school actually focuses on the actual working of the courts because the judges deliver judgments only in courtroom, and when they deliver the judgments they actually do brainstorming related to the facts of the case and what lawyers have to tell about that particular case. So the judicial decisions are considered as law in realistic school. So now we will be studying about the various proponents of realistic school of jurisprudence. So first proponent is Justice Holmes, which has given a very famous theory which is known as Badman theory. The seeds of realism were sown by Justice Holmes. He said that law is not like mathematics. Law is nothing but a prediction. So Justice Holmes is also considered father of realistic school. So he considers that law is a prediction and it is not a straight mathematical formula. What does it mean? Let us take an example. 2 plus 2 is equals to 4. So this is a mathematical formula, but we can also predict the answer 4 in some another way. So what can be the other way? It can be 5 minus 1 is equals to 4, or 6 minus 2 is also equal to 4. So this is what is prediction, which is emphasized by Justice Holmes. According to him, the life of law is logic as well as experience. The real nature of the law cannot be explained by formal deductive logic. Judges make their own decisions based on their own sense of what is right. In order to see what the law is in reality, he adopted the standpoint of a hypothetical badman facing trial. Therefore, his theory is also known as badman theory. So, what does this badman theory actually tells us about? Consider in a courtroom, there is a accused person who is facing a trial, and there are lawyers on the both sides. The party who is accusing the person tells various facts in support of getting him suffer punishment, but what the offender is thinking in his mind, he is thinking that there are some facts which are hidden or which can be taken by him in order to get rid of the punishment. So he knows some loopholes which are there in the law as well as facts which the court as well as the other party will not be able to identify. So he knows in his mind that he will face acquittal and not conviction. So how this is relevant in the present scenario in what Justice Holmes has to tell about. Justice Holmes tried to tell that we can consider that what law is actually what law is deemed to be by a bad man who is facing a trial. It means that bad man knows exactly what law is and how law should have been and what are the loopholes in it. So in order to better understand law, we should think from the point of view of a bad man facing a trial. This theory says that a bad man successfully predicts the actual law than other people. On the basis of this prediction, Holmes defined the law as prophecy's ability to predict of what the court will do, in fact, and nothing more pretentious. So he actually knows that what will be the decision or what are the points on which the court may decide accordingly. Next proponent about the realistic school is Justice Gray. His approach was certainly as court-oriented as realistic. So as he is also a proponent of realistic school, his approach will also be that whatever judges deliver or whatever is given in judgments is actually law. For Gray, the law was simply what the court decided. Everything else, including statutes, was simply sources of law. So what did Gray consider? Gray considered legislation, statutes, etc. to be sources of law and not law. So according to Justice Gray, the decisions given by the courts are law, and all the statutes and legislations which help to arrive at that decision are actually sources of the law. He said the law of the state or any organized body of men is composed of the rules which by the court status the judicial organs of that body lay down for the determination of legal rights and duties. So these rules or what the court has decided actually becomes the legal rights and duties which have to be followed by both the parties as well as has to be followed by the society at large, because this is how society will know that what is desirable to do and what should not be done. So till now we have studied two jurists or two proponents of realistic school of jurisprudence. First we have studied about Justice Holmes, and next we have studied about Justice Gray. So the third proponent which we'll be studying now is Levlin. According to Levlin, realism means a movement in thought and word about law. Karl Levlin outlined the principal features of realistic approach as follows. There has to be a conception of law in flux and judicial creation of law. Society changes faster than law, so there is constant need to improve the law. So first we will understand what this first point tells. It tells that society is also in flux and law is also in flux, because society is progressing, it is not stagnant. So whenever new situations arise, new conflicts arise, the law has to take note of that prevailing situation. So it's not possible that society be stagnant and law being stagnant. Both are in a flux in the present scenario. So what should be done to get rid of any ambiguities or conflicts? Society changes faster than law, so there is constant need to improve the law. Yes, I have given you an example of Sati Pratha. We have discussed in our previous classes that our society has progressed very radically from previous or ancient time. Now the society is much more developed, is much more westernized and much more modern. So will it allow Sati Pratha to be followed in today's time? Of course not. So by this we can say that the law, if it has been come here, or the society it has come to this level, then the law should also come to this level from this level. So both society and law should be at equal footing. So if society changes faster than law, there is constant need to improve the law. There has to be a temporary separation between what ought to be and what is the purpose of law. So what analytical school told that how we should consider law as it is and not how it is supposed to be. So in this case also, in realistic school, Levlin tried to tell that we should not look on how law is supposed to be, but rather we should look on how law is. Because if we take both the angles, that how law should be and how law is, then we will be in a chaos or confusion as to should we follow this law at the present, or should we wait till it get amended and then we follow it. So to avoid that confusion, we have to consider that the law is as it is now today. Carl Levlin described the basic functions of law as law jobs. Law is an institution which is necessary in society and which is comprised not only of rules but also contains an ideology and a body of persuasive and powerful ideals which are largely unspoken, largely implicit, and which pass unmentioned in the books. So Carl Levlin has given functions of law or law jobs. So what are the different functions of law we will be studying now? Law has jobs to do within a society. These are the disposition of the troubled case, a wrong, a grievance, a dispute. This is the garage repair work or the growing concern of the society with its continuous effect upon the remarking of order of society. So let us consider this is a society and it is facing a trouble. It means that there are individuals who are who are on the lives of others, or who are just thinking that how should they get the property of other, or how should they damage the other person life, liberty, or profession. So in this society, in that case, the society is in trouble. So to get rid of that trouble, law comes into picture. So law actually makes the society's trouble go away and results into a peaceful coexistence of individuals. So disposition of troubled case is a job of law. The preventive channeling of conduct and expectation so as to avoid trouble, and together with it the effective reorientation of conduct and expectations in similar fashion. So what do you mean by this statement? So the citizens have to do a conduct, or should do a conduct in an expected way which the society expects them to do. It means that they should not do something which is out of the box, or which the society does not accept a normal human or a normal prudent man to do and act. Third point, the allocation of authority and the arrangement of procedures which mark action as being authoritative, which includes all of any constitution and much more. Arrangement of procedures. What does it mean? It means that there should be some hierarchy established in arrangement of laws so that individuals are not confused that which law is supreme and which is subordinate. For example, let us consider the Constitution is always at the top as it is the supreme law. Then comes the IPC, then comes the CRPC, and then Indian Evidence Act. So this is the arrangement of procedures and authority which actually helps in better governing or better governance of the society. The positive side of law's work is net organization of society as a whole so as to provide integration, direction, and incentive. So what does law want to do? It wants that all people should live together and should not quarrel on minute things and should live peacefully. That's what law wants to do. So law wants us that we should inculcate the feeling of brotherhood, which is also written in our preamble as fraternity. So it wants us to provide integration and direction and incentive to the society. The next philosopher or next proponent which we will be studying is Jerome Frank, father symbol theory. So till now, which all philosophers have we studied? We have studied the father of realistic school, which is Justice Holmes, who gave the very famous theory, which is known as Badman theory, which tells that a bad man actually knows that what a law has, which loopholes, and how can he get rid of being convicted. Then Justice Gray says that judicial decisions are only the source of law, and legislations and statutes will be considered as source of law and not law. Llewellyn says that we have to see the society is also in flux and law is also in flux. So what can be done to avoid that flux is that the law and society should progress on the same footing. Carl Llewellyn has also told about the law jobs. So, disposal of trouble case is the first job, conduct and expectation and arrangement of procedures is the third job. Now we will look at what Jerome Frank has to tell about law. His theory is father symbol theory. His thesis is that a law is uncertain or certainty of law is legal myth. He exploded the myth that law is continuous, uniform, certain, and invariable, and asserted that the judges do not make the law, instead they discover it. So what does it mean? It means that as the father of a child nurtures him and the child has full faith in his father that the father will protect him and will provide all the security which the son needs. Similarly, the society also considers that the law which is prevalent now will actually make them feel safer and they will be able to work more efficiently. So, judges do not make law, instead they discover it. What does it mean? It means that the law is already made. For example, let us take Article 21, which tells us about right to life. So what does right to life includes? It means that all persons will have right to life, and right to life is a very basic fundamental right. So, but this right is already written. Judges do not have to write that there is this right existing. So judges do not make the law. It means that judges have not written what is Article 21. Instead, they have interpreted Article 21 to include right to privacy, right to environment, right to safe drinking water, right to dignity, which are included in right to life. So they have discovered that right to privacy, livelihood, environment, etc. are included in right to life. Frank observes that a judge's decisions are the outcome of his entire life history. His friends, his family, vocation, schools, religion, and all these factors are influential. So Frank is very frank in telling that a judge is also a person. He has also passed the stages. He has also been a young boy, and he has also been an adolescent, a youngster, an adult, and a mature person. So, while passing through all these stages, he have encountered many experiences which actually tell him that this should not have been done or this should have been done. He actually analyzes the past and tries that the same thing is not repeated in present and future if it is morally or legally wrong. So judges are also influenced by their past lives. So this is what Frank is telling about judges. In this regard, General Frank has given the father symbol theory. The child puts trust in the power and wisdom of his father to provide an atmosphere of security. In the adult, the counterpart of this feeling is the trust reposed in the stability and immutability of human institutions. So this is what I have told you, that the father, as the child has trust and in his father, similarly people of the country have trust in law. Frank accordingly divided realists into two camps, described rule skeptics and rules and fact skeptics. So what is the difference between rule skeptics and fact skeptics? Rule skeptics rejected legal rules as providing uniformity in law and tried instead to find uniformity in rules evolved out of psychology, anthropology, sociology, economics, politics, etc. So rule skeptics wanted to tell us that there can't be a law which is always in a same and which does not change over years. A law has to change with the change in society. And how does society change? Society is also influenced by many factors and many sciences. For example, society is influenced by anthropology, sociology, economics, politics, social science, etc. So rule skeptics want to tell us that legal rules keep on evolving. Similarly, the fact skeptics rejected even this aspiration toward uniformity. They also did not believe in uniformity. He abandoned all attempts to seek rule certainty and pointed to the uncertainty of establishing even the facts in the trial courts. So, fact skeptics tells that facts are also not uniform. It means that if two parties are there, then the facts may change according to the circumstances because the parties try to mold the facts and so that they can either be acquitted or either they can make the other party suffer penalty. So both law as well as facts are not uniform. Is what is the theory of law skeptics and fact skeptics. Now we will look at the various legal personalities. So this is a very interesting topic because now we will be looking at the logic behind why to consider a person, or what is actually a legal personality, what is personality, what is natural person, what are legal persons. So let's start now. Introduction. It means possession of certain characteristics particularly belonging to mankind. Example, power of thought of speech. It is derived from Latin word persona, which means who, recognized by law as being capable of having legal rights and duties. So what does personality means? Personality means a set of traits which define a person. It can be speech, it can be different things like walking, it can be the ability to think, it can be the ability to analyze. So these are the various traits a person has which makes him a personality. So now we will be looking at what various authors have to tell about legal personality. So a question might come in your mind that whether a person who is in coma for last 70 years can he be considered a legal personality, or can an unborn child be considered, or can a dead person be considered a legal or a natural personality? So these questions we will address now. So definitions. Salmond. According to Salmond, who is a legal personality? A person is any being whom the law regards as capable of right and bound by legal duties. So according to Salmond, it can be any person who is bound by legal duties as well as he has right. So a person according to Salmond is what we generally consider in modern scenario, because we consider that a person's existence is because of the fact that he has some legal rights and he has some legal duties towards others. So this is a very basic definition which we follow. Now what Savigny has to tell about the term person. The term person as a subject or bearer of a right. So according to Savigny, a person is considered a person when he bears a right. So we can actually infer from this statement that Savigny is not talking about duty. So, can an unborn child be considered a person according to Savigny? Or can an infant be considered as a person by Savigny? Yes, infant can be considered as a person by Savigny because he has rights. And how can he have rights? He has rights in property. He has some to because of the fact that he is born in that family. But does he have any duty? No, because he is not mature enough to have the capability to think right and wrong. So he does not have duty, but he has right. So according to Sevigny, an infant can also be considered as a legal as a person. Now what has Gray has to tell? A person is an entity to which rights and duties may be attributed. So he considers person as an entity, and he considers person as any being. So now what Austin has to tell? The term person includes physical or natural person, including everything which can be deemed human. So Austin has given a very broad definition of what is person. He includes legal personality as well as natural persons in his definition of person. So he also includes corporations, partnership firms, etc. to be considered as persons. Physical or natural person. So this is a very broad definition. Kinds of persons. Natural persons. A natural person is a human being possessing natural personality. So now we will be looking at what Holland has to tell about a person being a natural person. According to Holland, a natural person is a human being as regarded by the law as capable of rights and duties. Requisite of normal human being is that he must be born alive. Moreover, he must possess essential human characteristics. Generally, a person, human being who has capacity to sue and be sued is a person. So, according to Holland, there are two essential points for a person to be a person. First, that he should be born alive. That means a person is only the person who is alive. A dead person cannot be considered a person according to the Holland's definition of person. And second point which Holland has emphasized on is that the person should have some legal rights and duties. It means that in the court of law, he can sue somebody and he can be sued by the other party. So these are the two essential conditions. First, he must be born alive and should have rights and duties present. Now, next we will study about legal persons, also called as juristic, fictitious, or artificial persons. A legal person has a real existence, but its personality is fictitious. A fictitious thing is that which does not exist in fact, which is deemed to exist in the eye of law. Legal persons are beings who are treated for purposes of law as human beings. So consider an example company. A company as such is a legal entity because it is an artificial person. So the company consists of many persons like the board of directors, managers, secretary to the company, etc. So can the company be considered as a legal person? Yes, of course, it can be considered because even if it does not exist in fact, but it is deemed to exist in the eyes of law. And why it is deemed to exist in the eyes of law is because whenever a suit is filed against against the company, then the company's board of directors are liable and have to stand for the company. So it's not that whatever company does, it can do anything. It should also a law is applicable on company as well. So for law to be applicable on company, corporations, firms, they have to be considered legal persons. Dead person, he is not a legal person. They do not remain as bearer of rights and duties. They do not have action personis, morture cum persona. Action dies with the death of men. So do you think a dead person has some rights and duties towards other? He does not have any right and he does not have a duty. But do you know that a dead person has the chance that he can actually make some wishes or previously the wishes which have been made should be fulfilled by the other party who is actually the relative or the caretaker of the dead person. So he can actually make wishes and the wishes have been made previously. So the wishes and what he wanted to do should actually be done according to law, but he does not have rights and duties. Wishes or desires or intentions of a deceased person is recognized. Law ensures decent burial, their disposal of property, protection of reputation, or continuation of pending suits instituted by a person who is deceased. Consider an example where a dead person has, before his death, has instituted a suit against other party, and that suit is continuing. So, can the suit continue after the death of a person? Of course, yes, because death of the person does not give him a chance to have new rights and duties, but the previous commitments which he has done in his earlier stages should be kept in mind by the next generations in order to get better in the society. So he also has the right for a decent burial, their disposal of property, protection of reputation. So one cannot say anything malefic with relation to the dead person because he also has a right of reputation. And pending suits can also be continued after the death of a person. It also laid down in the English courts that permanent trust in the name of deceased. You might have heard that some dead persons wanted that they should actually give all their money and all their property in charity. This is the wish or desire of the deceased. So, a permanent trust or a charitable institution can be created after the death of a person. Unborn person. Law does not prevent a man from owning property before he is born. When is a person when is somebody considered a person? When a child is there in a womb of a mother, then till 3 months he is not considered a person. Then after 3 months he is considered to be a fetus. So this is how he is considered to be a person. The law does not prevent a man from owning property before he is born. So can property be given before a person has taken birth? So can property in his name be transferred? Yes. Let us take an example. Let us take the example of a grandfather giving property to his grandson at the time of at his deathbed, when the grandson has actually not taken birth. So this is possible. This ownership is contingent because he might not be born at all. But suppose the child is not born, he dies in the mother's womb. So, will that will which the grandfather has given for the grandson, will that hold true now also? Of course not, because the person has not come into existence at all. Under English law, a child in the womb of the mother is treated as the existence and property can be vested in its name. According to IPC and law of torts, the child in womb is considered to be person. Following other references to rights of unborn child. Under Section 13 of TPA, Transfer Property Act, for benefit of unborn person. So Section 13 of Transfer of Property Act tells that the property can be transferred to an unborn person for his benefit. Section 114 of Indian Succession Act, creation of prior interest before person, the unborn person. So an unborn person can have prior interest before the birth is written in Indian Succession Act. It means that what example I have given you previously, that a grandfather has transferred the property by will to his grandson who has actually not taken birth, is what is covered in section 114 of Indian Succession Act. Section 313 of IPC, offense of child destruction in the womb. So the child is protected this way. If a child is destructed in the mother's womb, then the mother has also some rights, and child has also the right that he should live and he should become a person. Then let us consider lower animals. Law does not recognize beasts or lower animals as persons because they are merely things and have no natural rights. Salman regards them as mere objects of legal rights and duties, but never subjects of them. So, should lower animals be considered persons? Some might think yes, they should be. They should be considered because in the present scenario, we see many cases in which animals are tortured, are killed by humans because they think they are commodities. But till now, the law has not recognized lower animals as persons. So, law does not recognize dogs, beasts, fishes, etc. to be persons because they are treated as mere objects. We buy and sell animals. We buy them as commodity. So the owner is a person who is buying that dog. So let us consider A bought a dog for 30,000 rupees from B. So the object of this sale or this agreement to sale is dog. And who has bought? A person, a living human being has bought that. And who is the object of this? Which I have told you, dog. So here dog is just considered as a commodity or thing which is bought and sold by persons. Mere objects. They cannot be owner of property from person to animal. So have you heard some fancy cases like people have given all their property in the name of the dog, and can that really happen? No, it is not possible because the dog is not considered as a person. This is what is written in third line. They cannot be owner of property from person to animal. They are themselves considered property to be owned, as I have told you that they are the object of the property. Any wrongs done by animal, the master is held liable in law of torts and is a strict liability. Consider the dog of your neighbor bites the person who is going on the street. So will that street person have some remedy against that dog? Of course, yes, because he can sue the owner of the dog. He can't sue a dog because dog is not considered a person. It is considered as a commodity. So the owner will suffer vicarious liability. Any wrongs done by animal, master is held liable. The animal is only a legal personality if the liability of master is considered vicarious. Theories of legal personality: fiction theory, concession theory, purpose theory, bracket theory, symbolistic theory, realistic theory, and organism theory. Fiction theory, promulgated by Pope Innocent IV. So now we will be studying about the various theories in relation to legal personality. The first is fiction theory. It is promulgated by Pope Innocent IV, supported by Savigny and Salmond. This theory suggests that the legal personality of entities other than human being is a result of fiction. Salmond has cleared that a human being is the only natural person, while legal person govern any subject matter other than a human beings to which the law attributes personality. State, corporation, and institutions cannot have rights of person, but they are treated as if they are persons. So by this, what can you understand? That Does fiction theory consider legal personality to be a person or just natural personality to be a person? It considers only legal personality as humans, as persons, and other than human beings are result of fiction. It means that we can make laws for corporations to work, for firms to work, for partnership to work, but we can't make them we can't consider them as persons, because according to Salmond and Sevigny, legal persons are only persons are to only natural persons are considered as persons. Then next is concession theory. It is linked with philosophy of sovereign national state. So what does concession means? Concession or creation. Who will create right and duties? Actually, a state confers the rights on an individual and gives him or her some duties to perform. So it is the state which actually gives the rights and duties to a person. This theory considers the state is considered to be the same level as the human being, and as such it can confer or withdraw legal personality. It means that state can give somebody some rights or duties, as well as it can withdraw rights and duties from a person when it thinks that it should withdraw from the other groups and association within its jurisdiction as an attribute of its sovereignty. So juristic person is merely a concession or creation of state. So what state wants is to be considered as person, and what state does not want should not be considered as a person. Jurists believing in this theory are Savigny, Dicey, and Salmond. So before that, we have done about one theory, which is the fiction theory, and the proponents of fiction theory were Savigny and Salmond, and the proponents of concession theory are Savigny, Dicey, and Salmond. It is merely a legal conception which indicates the law-making power unresting by any legal limits. Now next, we will look into the purpose theory. So what does the name purpose suggest you? When you look at the word purpose, what does it imbibe in your mind? It means that it will talk about something it will talk about the purpose of making of somebody or something as a legal person or person. So it declared that only human beings can be persons and have rights. Entities other than human are considered as an artificial person that merely function as a legal device for protection or getting effect to some real purpose. The property of juristic person does not belong to anybody, but it may be dedicated and legally found by certain objects. This theory rationalized the existence of charitable organizations, trade unions, etc. This theory considers only humans as persons, but it also tells us that persons may have something associated with it. And what is that? Something associated with it, and because that the persons will have purpose, and the purpose can be in the form of charitable institutions, which is written here, or in the form of trade unions. So trade unions and charitable institutions are not persons, but are the result of persons' purpose. So these are the results of persons' purpose. So the proponents of this theory are Brinz and Baker. Next is bracket theory. The proponents are Herring and Marquis. The connection of corporate personality is essential and merely an economic device by which simplify the task of coordinating legal relations. So have you heard a famous theory in company law, which is lifting of the corporate veil? It suggests that whenever a company is accused of doing any damage to the third party, then will the company be sued, or on the company's behalf the key managerial persons will be sued? Of course the key managerial persons will be sued. So how will we know that who is actually liable to be sued? For that, we have to go into the depth of the working of the company. And how we will go into the depth? By lifting the corporate wheel. It means that we have to enter into the company, see how it functioned and what all it did and what all it avoided. So this theory is actually what is the main theory of bracket theory. The connection of corporate personality is essentially merely an economic device by which simplify the task of coordinating legal relations. It emphasizes that law should look behind the entity to discover the real state of affairs. So this is what I have told you, that law should actually look behind the company or behind the existence of company. It should look into the person's doings. So big believer is lifting of corporate will. Now, next theory is realistic theory. Its proponent is Jonas Altunesis. So this theory is actually very practical theory in the modern scenario, as the name only suggests. This theory suggests that legal persons is real personality in an extrajudicial and prejudicial sense of the word. It assumes that the subjects of right need not belong merely to human beings, but to every being possesses a will and life of its own. So what does realistic theory tell us about? So this theory actually considers human beings as also persons. So natural persons are also considered person in realistic theory, and legal persons are also considered, legal personality is also considered person in realistic theory. It assumes that the subjects of right need not belong merely to human beings, but to every being possessing a will and life of its own. In this theory, a corporation exists as an objectively real entity, and the law merely recognizes and gives effect to this existence. So, according to this theory, corporation also exists as a real entity. It means it exists as a person. And what does law do? Law only recognizes that the corporation is a person. So, the function of law is recognition here. This theory also contends that law has no power to create an entity, but morally having the rights to recognize it. So this theory talks about recognition of rights and considers both natural person and legal persons to be persons. Organism theory, proponents Otto and Greg. This theory asserts that corporation is like organism and it has limbs in form of members and head, top authorities and other organs. So it considers that a corporation, there are some top managerial staff in a corporation and the normal staff which actually looks into the day-to-day functioning of the corporation. So the key manager staff is the head of the organism, and the staff which is lower to them are the limbs of the organization. So according to this theory, corporate has its own will and body which is subject to some legal right and obligations as well. According to this theory, corporate personality is a social organism which has its members' will. So by reading this, could you tell that whether natural persons are only considered person or legal persons are also considered person according to this theory? So as it very straightforwardly talks about corporate being a person, so of course natural person, natural personality and legal personality both are considered to be persons according to organism theory. Next theory is ownership theory. Proponents Bissins, Becker, and Demelius. According to this theory, they assert in the same manner that human beings only are subjected to legal rights, not corporations. Other beings are subject less property, which is creation of law, and this fictitious personality are there only for possession of property in common. So, by reading the first paragraph, what do you think is ownership theory? Human beings are only subjected to legal rights. So, it means that only natural person's personality is considered as person in ownership theory. And what are other things? Other things are only the subject of natural personality. It means the ownership of a property, etc., are subject of the personality. These personalities are only form of ownership. Being in such ownership, those personalities makes contract, sustain legal proceedings like actual persons. Means that whatever the natural person owns, or because of which it enters into contract or various agreements, is only possession of property, and it is not considered to be a natural person. So these are the various theories which we have discussed in today's class, and also we have discussed about last school, which was realistic school, which we have not discussed in detail previously. So till now we have discussed about half of the course, and in the remaining lectures we will be discussing about the remaining course as well. So till then, stay tuned and bye.